there must be presence of at least two parties. One is the person, one who is going to make an offer, and second is the person, one who is going to accept the offer. In simple, what is contract means? Contract is a combination of two aspects. That is, contract is equal to agreement plus enforceability. According to section 14 of our Indian Contract Act, we are not supposed to make a contract with the person who is disqualified by law. Hello everybody, a warm welcome to one and all. I am Mr. Hemant Kumar from the Department of Commerce and Management, Vidhyaashram First Grade College, MYSURU, the Temple of Excellence. In today's session, we are going with the subject Business Law, that is for 6th semester BBA students. This is Unit 1 and Session 1. Retake. This is Session 1 of Unit 1. It is about the Indian Contract Act 1872. In this unit, we are going to learn about the various aspects and the various lawful contents of the Indian Contract Act. Here, when it comes in terms of Indian Contract Act, it is going to govern the laws of India. It is applicable only for India, not for the foreign countries. This is agenda of today's session. We are going with Introduction to Indian Contract Act 1872, meaning and definition of contract, essential elements of a valid contract. So there are various essential elements or the essentials of a valid contract. So among them, we are going with offer, acceptance and consideration. Okay, so when it comes in terms of introduction, this Indian Contract Act 1872, it is going to govern the laws relating to the contract in our country. This act is based on the English or the British common law because this act was introduced by the Britishers in our country. This act is applicable to whole India, including the state of Jammu and Kashmir. Earlier, this law was not applicable for the countries of Jammu and Kashmir, right? Right now, it is applicable for the countries like Jammu and Kashmir after the removal or the revocation of Article 370, right? This Indian Contract Act came into effect on 1st September 1872, and also this Contract Act is applicable to whole India, including the state of Jammu and Kashmir, and whatever the contract that is going to happen in our country, it is governed by this Indian Contract Act. Meaning of a contract. So I said this Indian Contract Act, it is going to govern the contract in India. Okay, it is applicable to whole India, and also introduction of this act by the Britishers and also the implementation of the act, right? So what exactly the contract is? Okay, so according to the section 2 subsection H of the Indian Contract Act, a contract is a binding agreement between two or more parties. Okay, so it is a binding agreement between two or more parties creating a mutual obligations. Please note down this point, which is going to create the mutual obligation that is enforceable by law. Okay, so beautiful it is. Okay, so I repeat, a contract is a binding agreement between two or more parties creating a mutual obligation that is enforceable by law. Here we need to recognize three things. First thing, it is a binding agreement. Okay, so it is a agreement which is going to bind the two things. Okay, so which is going to happen between two or more persons. Okay, this contract can happen between two persons or more than two persons. Okay, so there must be minimum presence of two persons. It cannot happen between a single person. Creating a mutual obligation that is enforceable by law. So whatever the obligation that is created, that must be mutual in the nature, and that obligation must be enforceable by law. That obligation must be legal. That obligation must not be illegal. Okay, so again, it is a formal promise or set of promises. So as I said, there must be presence of two parties to consider it as a valid contract. Okay, so the parties, okay, so there are two parties means let us consider those two parties as Mr. A and Mr. B. Okay, the contract is going to happen between two parties. Okay, so either two parties or more than two parties. The one who is going to offer something to Mr. B. Say for an example, Mr. A is going to offer a chalk piece to Mr. B. So it is called as a offering. Okay, so he is going to offer the chalk piece. We call him as a offerer. Okay, so he is going to accept the offer. We call him as a offeree. Okay, so he is the one who had offered. We call him as a offerer, and also we call him as a promiser. He is the one who is going to receive the promise. We call him as a promisee. Okay, so promiser, promisee, offerer, offeree. Okay, so there must be existence of two parties. It is a formal promise or a set of promises. Okay, so he had promised to give 1 lakh rupees based on the consideration for his car. Okay, so there is a promise or a formal promise or a set of promises. So again, so behind that promise there are a number of promises that is made by Mr. B and also Mr. A. So because Mr. A is going to give him his car and Mr. B is paying him the amount for the car, that is 1 lakh rupees, that is the consideration. Okay, so that specify the rights and duties of each party involved. Okay, so here when it come in terms of the contract, before starting the contract itself, all the terms and conditions will be mentioned in the contract in terms of A also, in terms of B also. So if the terms and conditions are clear and there is a free consent, okay, it will become a valid contract. Okay, so in simple, what is contract means? Contract is a combination of two aspects, that is contract is equal to agreement plus enforceability. Okay, I repeat. So if we consider it as a formal contract or if we consider as a lawful contract, okay, there must be presence of a agreement that is going to happen between two parties, and there is something called enforceability that must be legal, it must not be illegal, which must be enforceable by Indian law. Okay, so contract is equal to agreement plus enforceability. What is this agreement is about? Okay, so this agreement is a promise or a set of promises that is made by the parties. Okay, so when it comes in terms of a agreement, there are two factors that is going to influence the agreement. Factor number one, it is a offer, and factor number two, it is the acceptance. Okay, so to consider a valid agreement, there must be presence of two aspects. One is offer and another one is acceptance. Okay, so what is offer? Say for an example, Mr. A want to sell his car. Okay, he is going to offer Mr. B to purchase his car. That is considered as a valid offer, and Mr. B is going to accept the offer that is given by the Mr. A. So he is going to offer him a car, he is going to accept, then it is going to become a valid agreement. Okay, so what happens if he offer his car, he refused to accept the offer, it cannot become a valid agreement. Okay, so it cannot become an agreement itself. Okay, so there must be two parties, one should offer and another should accept, then only it is going to become a agreement. Okay, so agreement plus enforceability. So whatever the things these both people are doing, it must be enforceable by law, it must be legal in nature. He cannot make an agreement saying that Mr. B should bring a head of Mr. C. It is a void contract, it cannot become an agreement also, it cannot become a contract also. Then what are the difference between the agreement and a contract? This is a common doubt that can arise, okay, in the minds of people. Okay, so one is agreement, another one is contract. Here I am going to give you a twist. All the contract can become a agreement, but all the agreement cannot become a contract. I repeat, all the contract can become a agreement. Okay, so all the agreements cannot become a contract. Okay, how? Because here, when it comes in terms of agreement, there may be two kinds of obligation. One is social obligation. Second one is lawful obligation. When it comes in terms of agreement, there is social obligation, there may be lawful obligation. Both the obligation can formulate the agreement. But when it comes in terms of a contract, there must be only lawful obligation, there must be no social obligation. I will give you one best example for social obligation and lawful obligation. When it comes in terms of a social obligation, Mr. A invite Mr. B to his marriage, okay, but due to some reasons, Mr. B could not able to go to his marriage and attend the function, okay. So now the Mr. A cannot claim or he cannot sue against Mr. B in the court of law, because whatever the things that had happened, it is a social obligation. Invitation for a dinner, invitation for a marriage, invitation for a function, yes or no? So these all things are the social obligation. And another the example for the social obligation is Mr. A offers car to Mr. B, okay. Mr. B is going to accept the offer, it is going to become a lawful contract, it is a lawful obligation, okay. Because when it comes in terms of a social obligation, there is no consideration, there is something called consideration, okay. In social obligation, there is no consideration. In lawful obligation, there is a consideration, there is a presence of consideration. What do you mean by this consideration, sir? Okay, so this consideration is a thing that is required by Mr. A from the Mr. B, or it is the requirement of Mr. B from the end of Mr. A. As I gave you the example, okay, so what is consideration? Okay, so as I said, Mr. A is going to offer Mr. B a car, okay. So Mr. B accept the offer and also he agreed to pay 1 lakh rupees for his car. So it is a valid contract, valid agreement, okay. So no doubt in it, okay. What is the consideration of Mr. A? Okay, so in terms of Mr. A, the consideration is 1 lakh rupees which he is going to receive from the end of Mr. B. What is the consideration from Mr. B? It is a car that he is going to receive from Mr. A. That is nothing but consideration. So as I gave you the example, in the lawful obligation, there must be consideration for both the parties. So when it comes in terms of Mr. A, 1 lakh rupees is a consideration, Mr. B, car is a consideration, okay. So but in a social obligation, there is no consideration with the by the end of two parties, okay, because just they are going to invite for the party, okay. So just they are going to invite for some other function, they are going to invite for some other thing, okay. So that cannot become a lawful contract, okay. So that is the difference between the contract and the agreement, okay. So I repeat, the agreement can, because of two obligation, one is social obligation and another one is legal obligation, but contract is going to happen just because of the legal obligation, not for the social obligation, okay. So that is the difference between the contract and the agreement. Hope you people are familiar with the concept. Moving forward, definition of a contract. Sir John Solomon defined a contract as an agreement creating a defining obligations between two parties, okay. So as I said, there must be a obligation of two parties, there must be a mutual obligation of two parties, okay. Say for an example, Mr. A is going to offer Mr. B a car, but Mr. B obligation is not a car means, so it cannot become a valid contract, okay. So if Mr. A is going to offer the car to Mr. B, he must accept the same car with the free consent, okay. So there must be no coercion, there must be no undue influence. Sir Frederick Pollock defines every agreement and promise enforceable at law is a contract, okay. So every agreement that is enforceable by law, because those agreement which can be enforceable by law have two things. One is the legal obligation, second one, there is a consideration. When it comes in terms of the agreement that is not enforceable by law, there is no consideration and also there is no legal obligation. It may be a social obligation. Essential elements of a valid contract. To consider a contract as a valid contract, there must be a presence of a certain factors. Which are those factors that is going to influence a contract to become a valid contract? So plurality of parties. So when it comes in terms of a plurality of parties, there must be presence of at least two parties. One is a person, one who is going to make an offer, and second is a person, one who is going to accept the offer. Offerer and offeree. Okay, so offer and acceptance. So in the plurality of parties, there must be presence of two parties. So we shall take an example of Mr. A and Mr. B. Okay, so when it comes in terms of a offer and acceptance, so A is going to offer B something. Okay, he is going to accept the offer. Okay, so there is no acceptance without offer. There is no offer without acceptance, because if there is no acceptance also, it cannot become a valid contract. If there is no offer also, it cannot become a valid contract. Okay, so if there is only the person who is going to offer, there is no person to accept the offer, it cannot become a valid contract. Lawful consideration. So lawful consideration means there must be consideration with the end of both the parties. Okay, so say for an example, as I said, Mr. A is going to offer car to Mr. B. Okay, Mr. B is going to accept the car for paying 1 lakh rupees. Okay, so consideration for Mr. A, that is 1 lakh rupees. Consideration for Mr. B, it is the car that is offered by Mr. A. Okay, so there must be a consideration with the end of both the parties. According to section 25 of the Indian Contract Act, it is going to say about a valid contract must consist of a consideration. If there is no consideration, it will become a void contract. Okay, so void contract means it is invalid and it is not enforceable by law. Legal obligation. So the obligation or the intention must be legal, it must not be illegal. As I gave you the example, so Mr. A cannot make the contract with Mr. B saying that you must bring the head of Mr. C. Okay, so it is not the legal obligation, it is an illegal obligation which is not enforceable by law. Okay, so if a contract must considered as a valid contract, there must be a legal obligation. Okay, so the legalities must be present. Capacity of parties. So when it comes in terms of a capacities of parties to consider it as a valid contract, okay, so there must be a capabilities of a parties, there must be a basic element that must be present in a particular person where we are going to make a agreement. Okay, so when it comes in terms of a capacity of parties, there are few category of people which is restricted by law. So which are all the people which is restricted by Indian law? Number one, minor. Okay, so if he or she, they are minor, according to section 11 of Indian Contract Act, we are not supposed to make any kind of a contract with him or her. Okay, so again, according to section 12 of Indian Contract Act, we are supposed to make a contract with a sound-minded people, not with the unsound-minded people. Okay, so because unsound-minded people, they cannot understand the law, they don't know anything, and it will become a void contract. And again, according to section 14 of our Indian Contract Act, we are not supposed to make a contract with the person who is disqualified by law. Okay, when it comes in terms of a disqualified by law, it is categorized into three categories. Number one, we are not supposed to make a contract with the insolvent person who is declared as insolvent by the court of law. Number two, we are not supposed to make a contract with convicts, means the person who get prisonized under various acts. And again, also there are certain terms and conditions of which he is get prisonized. Okay, so again, and number three, we are not supposed to make a contract with the people of the enemy country which had fought a battle against our country. Okay, so these are the three aspects we must consider under the section 14. I repeat, three sections together. Okay, number one, section 11 of Indian Contract Act, it is going to say about we are not supposed to make a contract with minor people. Okay, they must at least be the age of 18 or 18 plus of age. Okay, so number two, we are not supposed to make a contract with a unsound minded people. We are not supposed to make a contract with unsound minded people. Number 3, 14 of the act, there are certain category of people which is restricted by law. Number 1, it is insolvent. Okay, so we are not supposed to make a contract with the insolvent people. Number 2, we are not supposed to make a contract with the people who had prisonized. Okay, so for a specified period of time and later. Number 3, we are not supposed to make a contract with the people who belong to the enemy country. So if we make such a kind of contract, it is not enforceable by law. This contract may become a void contract. Free consent. So when it comes in terms of a free consent, so there must be no coercion, there must be no misrepresentation, there must be no fraud. Okay, so they must be willingly make a contract with each other. Lawful object. The objective of the contract must be lawful and it must not be illegal. Okay, so they cannot make the contract to supply the drugs because it is illegal in our country. So whatever the contract that is going to happen, it must be certain. Okay, and possibility of performance. Okay, so whatever the contract that is going to happen, so that must be possible to perform the particular thing or activity. So it cannot be performable. Okay, so best example is the contract between the employer and the employee. Okay, agreement not declared void or illegal. Okay, so which are the agreements that is not illegal can be considered as a contract. The agreement which is illegal in nature cannot consider it as a contract. Legal formalities. So whatever the formalities that is offered and accepted by the two parties, that must be legal in nature, it must not be illegal. Offer and acceptance. Already we know the meaning of offer. Offer is an initial step in creating a contract where a party, the offerer, communicates their willingness to perform a specific act or refrain from doing something to another party. That is nothing but the offer. Okay, so because he is going to offer something to someone. Essentials of valid offer. If an offer should considered as a valid offer, there must be presence of essential elements. Okay, so one is communication. So they must communicate with each other all the terms and conditions that is relevant to the contract. Intention to create a legal obligation. As I said, there must be no social obligation, there must be intention to create a legal obligation. Social obligation, it is a void contract, it is invalid. Specificity. Okay, specificity means they must be very specific about the thing or the consideration. Say for an example, as I gave you, okay, Mr. A is going to offer Mr. B his car. Okay, so he must be particular about the car which he is going to offer Mr. B. Say for an example, Mr. A have 3 cars, red, blue and green car. Specifically, he must say that I am going to sell my red color car, okay, to Mr. B, and also Mr. B must specify I am going to give you 1 lakh rupees within a specified period of time. There must be specificity in terms of the contract, in consideration of the contract and all the aspects of the contract. Intention of the parties. So intention of the parties means both the parties must have the same intention. Say for an example, A is going to sell his car, the B must have the intention of purchasing his car. Okay, if he is not intended to purchase the car, it cannot become a valid contract. No social or domestic invitation. No one is going to invite socially to enter into a contract. Okay, it is going to happen only between the 2 or more persons. No silence or implied acceptance and express or implied offer. Okay, so here it is a very important thing that you must keep in your mind in the essential elements. Okay, so what is this implied offer and implied acceptance? Okay, so implied offer means it is going to offer something by just the gestures. Say for an example, so in implied offer, just I say like this. You think, oh, sir is going to offer me a pen. Okay, so it is an implied offer. It is not expressed, it is not verbal in nature, it is not written in format, just because of the accents that they are going to recognize the offer and acceptance. Okay, according to the Indian Contract Act, implied offer means if I say like this, so what do you think? So sir is going to offer me a pen, and if you accept the pen, it will become a valid offer. Okay, so it will become a valid offer. When it comes in terms of acceptance, implied acceptance is not applicable in this law. Okay, so how? Say for an example, so Mr. A offer me his car for 1 lakh rupees. Okay, so if I am silent, so I stand just like this. Okay, so there is no expression from my end, so it cannot become a contract. Okay, again, so if I implied acceptance. Say for an example, he offer me a car. Are you going to purchase my car for 1 lakh rupees? Just I nod my head. Okay, so it also not considered as a acceptance according to the Indian Contract Act. Nodding the head, gestures are not considered as a implied acceptance, but implied offer will be considered in the law. General or specific offer. Okay, so there must be a general offer or the specific offer that is enforceable by the law. General offer is the offer that is made to the group of people, group of a society, so that we call it as a general offer. Specific offer, if I make a offer for the specific group of people, okay, specified person, okay, so that we call it as a specific offer. Offer and acceptance. So we had gone through the concept of offer and again the concept of acceptance. Acceptance means final and unqualified expression of the agreement to the terms of proposal. Okay, so it is unqualified in nature, but when it comes in terms of a proposal, okay, so if they are okay with the proposal only, they can accept the offer. There must be no undue influence, there must be no undue influence, or there must be no coercion, or there must be no fraudulent purposes. This assent is given to the person to whom the proposal is made. So proposal is made to the person means, for an example, there must be presence of minimum 2 persons. Okay, so one is going to offer something, is going to accept something. This proposal is made to the person, one who is going to accept the offer within the time specified in the proposal, or if not, time is specified within a reasonable time. Say for an example, Mr. A offer car for Mr. B today. He cannot accept the offer after 1 year or after 2 years. Okay, within the specified period of time that is mentioned by the offerer, he have to accept the offer, or else it will be revoked. Absolute and unqualified. Okay, so the offer must be absolute and the things or the contents which is illegal will be unqualified. Communication. Okay, so he must communicate his acceptance. So there must be he cannot just say by gesture like this or these all things. Okay, so either it must be oral or it must be in the written format. Reasonable time period. Within the specified period of time that is mentioned by the offerer, he must accept the offer or reject the offer. Implied acceptance. So when it comes in terms of the implied acceptance, so the gestures, okay, so these all things will not considered according to the law. By the intended person. Okay, so he must only receive the offer by the intended person, the one who is going to make the offer. Okay, so he must receive the offer only by the person, one who offered him something. Say for an example, so Mr. A is going to offer something to Mr. B. Okay, so B must accept the offer of Mr. A. He cannot expect the offer from Mr. C. Okay, so he must accept the offer that is made by the offerer. Consistency with terms. So there must be consistency with terms and condition which had been mentioned earlier. No revocation. Okay, so after making the contract, there is no opportunity for the revocation of the offer that is accepted. Okay, so after accepting the offer, they are supposed to perform the activity that had been promised. Consideration. Okay, so as I said, there must be consideration to consider a valid contract. Okay, according to section 25 of Indian Contract Act. Consideration refers to something of value, benefit that the promisee, the person receiving the promise. Okay, so he must take some benefit out of the thing that they are going to make a contract. Without benefit, nobody will make a contract. If a contract must considered as a valid contract, there must be something element called consideration. Provides the promiser, the person making the promise. Okay, so in exchange for the promisee. Okay, so again I repeat, so if agreement is going to happen between Mr. A and B, there must be consideration in terms of Mr. A and also Mr. B. There must be a valid consideration. Okay, so that is what they had mentioned. Consideration means something in return. So consideration is something in return, as you gave you the example. Okay, so Mr. A is going to offer B the car. Mr. B is going to offer him 1 lakh rupees. Again, accept, and he is going to offer him 1 lakh rupees. Okay. So what is his consideration? Car is the Mr. B consideration. Mr. A consideration is 1 lakh rupees. So that's what they said. Consideration means something in return. Okay. So he's going to collect 1 lakh rupees from Mr. B. So what is going to give Mr. B as a return? Okay, car. Okay. So Mr. B is going to collect the car. In return, he is going to give 1 lakh rupee. There must be something for something. It must be a act or absence of promise. As I said, so it is a absence or a promise that is made and agreed by both the parties, which had been discussed early. So this is the last concept of today's session. Essentials of a valid consideration. There are few elements that is essential to consider a valid consideration. So number one, given at a desire of a promiser. So as I said, there must be presence of two parties. One is a promiser, another person is a promisee. Okay, so he is going to offer something to Mr. B. So given at a desire of a promiser, so he is going to fulfill the desire of promiser. For example, he is going to offer his car for 1 lakh rupees. The desire of Mr. A is 1 lakh rupees. Okay, so that Mr. B must fulfill his desire by the promisee or any other person. Okay, so this desire can be fulfilled by the promisee, that is Mr. B, or any other person in the place of Mr. B can fulfill the desire of a promisee, can fulfill the promise of promiser. Real, certain and lawful. Okay, so whatever the terms and conditions that is applicable in the Contract Act, it must be realistic in nature, and there must be certain, it must not be uncertain, and it must be lawful in nature, it must not be illegal in nature. Adequate, it is a formal feature of a contract. The consideration must be adequate. Okay, so to consider as a valid contract. Executed and executory. Okay, so the contract that is made between the two parties, that can be executed now itself, or it may be executed in future also. They can make a agreement. It is a valid contract. Not necessary equal. Okay, for example, so he is going to, as I said, Mr. A is going to give Mr. B car, and he is going to receive 1 lakh rupees. So it is not mean that this car is equivalent to 1 lakh rupees. So he can receive 1 rupee also, he can receive 10 lakh rupees also. Okay, so there must be no equivalent value for the thing that they are going to do based on their agreement. Okay, so they are going to consider the things. It does not mean that he is going to sell his car, they are supposed to give her certain amount or the same value of the car. Okay, so the value may be increased or value may be decreased according to the Contract Act, but there must be a consideration. Okay, so Mr. A can receive 1 rupee also, that is also considered as a consideration under the Indian Contract Act. Not limited to natural love or affection. Okay, this contract is not related for the natural love and affection. Okay, why it is not applicable for the natural love and affection? What is the reason? Because this natural love and affection can become a social obligation. It is not a lawful obligation. I will give you another best and a beautiful example, dear students, at the end of the session. Okay, so love and affection cannot become a valid contract. Okay, so how? In love and affection, there is no consideration. If there is a consideration, it is considered as a valid contract. Okay, say for an example, there is a father and a daughter. Okay, so be very careful while listening the example. So there are two persons. Okay, one is father and another one is daughter, his daughter. Okay, so father offer his daughter saying that if you score distinction in SSLC, I am going to offer you a scooty. Okay, so if you score distinction in SSLC, I am going to offer you a scooty. Okay, so what does she do? So she is going to work hard and score distinction in SSLC. So what happened is her father refused to offer her a scooty just because of the reason she doesn't know to ride a scooty. Okay, so she cannot claim a case against the father in the court of law. Okay, she cannot claim against her father. Okay, because there is something called love and affection, and there is a absence of consideration. There is no consideration at all. Okay, so it will become a social obligation, the agreement between father and a daughter. And again, the same father is going to offer her daughter a scooty. Okay, so for 10,000 rupees. Okay, so a father is going to sell his scooty to her daughter. Okay, so for 10,000 rupees, it is considered as a valid agreement because there is no social obligation, there is a lawful obligation. Okay, because there is a consideration, the consideration of a scooty and a 10,000 rupees. So that can become a valid contract. These are the difference between the social obligation and lawful obligation. Please don't get confused. It is a main part of the essential, that is social obligation and lawful obligation. The concept is very easy. So if you keep going with the videos, if you keep going with the study materials that I'm going to provide, that is much than enough to score a good marks in final exam. Coming to the next session. Okay, so we are going with contractual capacity, free consent, and classification of contract. So when it comes in terms of a classification of contract, it is classified into various categories. Okay, again, contractual capacity, the capacities of the individual parties. So free consent. Okay, so when it comes in terms of free consent, okay, so they must willingly they are supposed to offer or accept the offerings that is made by the parties. Okay, there must be a free consent, there must be no coercion, there must be no undue influence, there must be no fraudulent purpose. Okay, so these are all the things that we need to learn in depth in next session. Thank you.